Good afternoon and welcome all to the weekly business meeting of the South Carolina Public Service Commission. Today is Thursday, August 14th, 2025, and it is approximately 1 p.m. Before we begin the meeting, would you please join me in a moment of silent reflection? Thank you very much. Present in the hearing room are Commissioners Belser, Commissioner Caston, Commissioners Carol Lee Williams, Commissioner Thomas, Vice Chair Williams, and I am Chair Powers. Commissioner Britt is in judicial training and will not participate in today's meeting. But Scarborough, if you would, please proceed with our docket today.
Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the date of the next regularly scheduled Commission business meeting. Staff recommends that the next Commission business meeting be set for Thursday, August the 21st, 2025 at 1 o'clock p.m.
The next business meeting will be Thursday, August 21st at 1 o'clock p.m.
Thank you, sir. Today we have 11 items on the utilities agenda and 11 items on the transportation agenda. Item number 1 has been deleted from today's agenda. Item number 2 is in docket number 2023-89E. This is a request from Duke Energy Progress, LLC for approval of its true-up calculations and proposed adjustments to the storm recovery charges that were approved in this docket for those adjustments to become effective on September 1st, 2025.
As to item number 2, is there a motion?
Mr. Chairman.
Commissioner Belser.
Thank you. Mr. Chairman, fellow commissioners, let me just give some background first, I think. In accordance with Commission Order Number 2023-752A, and as the servicer of the Senior Secured Series A Storm Recovery Bonds, Duke Energy Progress, LLC filed on June 23, 2025, its second true-up adjustment letter and request for a true-up adjustment to the storm recovery charges as provided by the South Carolina Storm Damage Recovery Act, contained in South Carolina Code Annotated Sections 58-27-1100 et sec. Section 58-27-1110C4 states that if the Commission issues a financing order and the storm recovery bonds are issued, the electrical utility shall file with the Commission at least annually a petition or a letter applying the formula-based mechanism and based on estimates of consumption for each rate class and other mathematical factors, requesting administrative approval to make the applicable adjustments. The statute also provides that the review of the filing shall be limited to determining whether there are any mathematical or clerical errors in the application of the formula-based mechanism relating to the appropriate amount of any overcollection or undercollection of storm recovery charges and the amount of an adjustment. The Commission's Order Number 2023-752A, dated October 23, 2023, and referred to as the financing order, states in paragraph 23 that a true-up adjustment letter, as described in this financing order, shall be based upon the cumulative differences, regardless of the reason, between the periodic payment requirement and the actual amount of storm recovery charge remittances to the indenture trustee for the series of storm recovery bonds. By its second true-up letter, Duke Energy Progress seeks an adjustment to the storm recovery charges. ORS, by letter filed on August 4, 2025, advises that ORS reviewed the filing for mathematical and clerical errors in the application of the formula-based mechanism relating to the appropriate amount of any overcollection or undercollection of storm recovery charges and the amount of adjustment. ORS found no such letters contained in the true-up adjustment letter. Having reviewed the filings submitted by Duke Energy Progress and ORS, and in accordance with Section 58-23-1110C4 and Commission Order Number 2023-752A, I move that the Commission approve the true-up adjustment letter submitted by Duke Energy Progress, LLC on June 23, 2025. So move.
Thank you, Commissioner Belser. Motion has been made by Commissioner Belcher. Is there any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 3 appears in docket number 2025-156E. This is a petition from Dominion Energy South Carolina Incorporated for an accounting order related to a certain cost from Hurricane Helene.
That's item number 3. Is there a motion?
Chair Powers,
Commissioner Thomas.
I move that the Commission grant the petition of Dominion Energy South Carolina Incorporated, or Dominion, for an accounting order or petition. In moving to grant the petition, I also move that the Commission find and conclude that the petition complied with the applicable law and requirements of Order Number 2023-38. Specifically, Dominion addressed the two-pronged test, 8 considerations, and the estimated impact on revenue and rates as required therein. Dominion's deferral request details the estimated revenue impact to Dominion as follows. Asset retirement cost of removal, approximately $9 million total revenue impact. Deferral of depreciation expenses, approximately $4 million total revenue impact, and deferral of carrying costs using cost of debt, approximately $4.8 million total revenue impact. As a result of granting the petition, Dominion shall have the authority for regulatory accounting purposes to defer and record as regulatory asset carrying cost on the balance in the deferred cost regulatory assets at Dominion's previously approved cost of debt rate in effect at the time the deferral cost was incurred relating to matters included in the petition as follows. 1. Reclassify the net carrying value of assets that Dominion Energy South Carolina retired as a result of damage from Hurricane Helene and associated cost of removal to unrecovered plant regulatory asset accounts. 2. Amortize the unrecovered plant regulatory asset balances and associated cost of removal in amounts equal to the level of depreciation expense previously being recorded for the assets at the time of their retirement. 3. Defer depreciation expenses from plant assets placed into service to replace the retired assets. And 4, record carrying costs on the balance in the deferred cost recovery asset pertaining to Hurricane Helene damage and service restoration. In order number 2021-570 and issued in docket number 2020-125E, the Commission approved a cost of debt of 5.56%. In the company's most recent retail electric general rate case, docket number 2024-34E, the Commission approved a cost of debt of 5.7% as memorialized in order number 2024-610. Entry of this accounting order does not result in any changes to Dominion's retail electric rates at this time. As noted in order number 2023-38, the entry of an accounting order only provides a method to track and record costs and does not result in any finding involving prudency and reasonableness for the purposes of cost recovery. Additionally, I further note that on August 7, 2025, the Office of Regulatory Staff does not oppose the company's deferral request. Issuance of this accounting order will not preclude any party from addressing all utility rate-making aspects of these costs in any future proceeding where cost recovery is sought, including but not limited to reasonableness and prudency of the cost, calculation of carrying costs only being applied on prior month balances, calculation of the deferral balances, review of the underlying costs deferred, amortization period for recovery, whether to include the unamortized balance in rate base, and any potential cost offsets and any customer protections. Therefore, Parties may make recommendations concerning the recovery of deferred amounts in future rate or cost recovery proceedings, and the Commission maintains its authority to make determinations regarding cost recovery of deferred amounts. So move.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all in favor signify by saying aye.
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 All opposed by no. The ayes have it. The motion carries.
Item number 4 has been deleted from today's agenda. Item number 5 is in docket number 2025-154E. This is a motion from Duke Energy Progress LLC for leave to file the direct testimony of Stephen Capps, who is adopting the pre-filed testimony of witness Tom Simrell in this proceeding.
As to item number 5, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. This matter comes before the Commission by the request of Duke Energy Progress, LLC, for leave to file the direct testimony of Stephen D. Capps, Senior Vice President of New Nuclear Development and Operations Support, adopting the pre-filed direct testimony of Duke Energy Progress witness Tom Simrell in this proceeding for good cause. On June 12, 2025, Duke Energy Progress filed its application, minimum filing requirement schedules, pursuant to South Carolina Code Annotated Regs 103-823A3, and supporting direct testimony and exhibits. Among these were the pre-filed direct testimony and exhibits of Duke Energy Progress witness Tom Simrell. Since then, on June 16, 2025, Mr. Simrell transitioned to a new role within the company. The company therefore requests that witness Stephen Capps be allowed to adopt the direct testimony of Mr. Simrell in full, with the exception of the revised introduction and overview section as indicated on page 5, lines 13 to 14 of Mr. Capps' testimony. The company further asserts that no party will be prejudiced by this motion, given that Mr. Capps would adopt the pre-filed direct testimony and exhibits of Mr. Simrell previously pre-filed with Duke Energy Progress's application, and that other parties still have time to respond. For these reasons, Duke Energy Progress requests that the Commission grant this motion and accept the attached pre-filed direct testimony and exhibits of Stephen D. Capps as filed, adopting the testimony and exhibits of Tom Simrell. I move that the Commission grant the request of Duke Energy Progress to allow Stephen Capps to adopt the pre-filed direct testimony and exhibits of Duke Energy Progress witness Simrell, with the exception of the revised introduction and overview section as indicated on page 5, lines 13 to 14 of Mr. Capps' testimony. This will not prejudice, cause undue hardship to any party. The clerk's office is directed to accept the pre-filed direct testimony and exhibits of Stephen Capps, adopting the testimony and exhibits of witness Simrell.
Thank you, Commissioner Williams. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 6 is in docket number 2025-173E. This is a petition to intervene in this docket filed by Mr. Anthony G. Bryant.
As to item number 6, is there a motion? Commissioner Belser.
Thank you. I move that the Commission deny the petition to intervene of Anthony G. Bryant. South Carolina Regs 103-825A3 requires that a petition intervene in a matter pending before the South Carolina Public Service Commission must set forth clearly and concisely A, the facts from which the nature of the petitioner's alleged right or interest can be determined, B, the grounds of the proposed intervention, C, the position of the petitioner in the proceeding. Mr. Bryant submitted the email on July 21st, 2025 as both a petition to intervene and a letter of protest. I move that the Commission find and conclude that the email does not meet the criteria required by South Carolina Regulations Annotated 103-825A3 because it does not set forth the facts from which the nature of the petitioner's alleged right or interest can be determined, the grounds of the proposed intervention, and the position or the position of the petitioner in the proceeding. I note that on July 24, 2025, Dominion Energy South Carolina Incorporated filed a letter of objection in opposition to the petition to intervene, asserting that Mr. Bryant did not meet the requirements of Regulation 103-825 when making a petition to intervene. Mr. Bryant replied in support of his petition to intervene on July 31, 2025, and in response to Dominion. After review of these filings, I move the commission find and conclude that Mr. Bryant fails to establish the grounds and right to intervene in this docket. However, the email submitted by Mr. Bryant on July 21, 2025, and his reply comments filed on July 31, 2025, shall be maintained in this docket by the clerk's office as a letter of protest. So move.
Thank you, Commissioner Belser. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 7 is in docket number 2025-240C. This item involves appointing a hearing examiner in this docket.
As to item number 7, is there a motion?
Chair Powers,
Commissioner Thomas.
I move that the commission appoint David J. Stark, Esquire, as hearing examiner in docket number 2025-240C.
Thank you, Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 8 has been deleted from today's agenda. Item number 9 is in docket number 2023-162WS. This is a motion from Lakewood Utilities Incorporated for leave to withdraw its application for an adjustment in rates and charges.
As to item number 9, is there a motion?
Chair Powers,
Commissioner Caston.
thank you. On August 11th, 2025, Lakewood Utilities LLC filed a motion for leave to withdraw its application pursuant to South Carolina Code Section 58-3-225, subsection E. This subsection provides that a party may withdraw its application prior to the later of the date that responsive pleadings are filed, or the date that the withdrawing party's direct testimony addressing such application is due to be filed with the Commission. Upon review of the DMS and docket, the intervening parties, including the Office of Regulatory Staff, have not filed any responsive direct testimony or exhibits in response to Lakewood's application. The due date for pre-filing direct testimony as scheduled by the Chief Clerk is October 10th, 2025. I move that the Commission grant the motion of Lakewood Utilities LLC to withdraw its application filed on July 15th, 2025.
Thank you, Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 10 appears in docket number 2025-177E. This is a motion from Santee Cooper for leave to file supplemental testimonies of Christopher Wagner and Sarah S. Kent.
As to item number 10, is there a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, based on the reasons stated in Santee Cooper's letter requesting leave to file supplemental testimony filed on August 11th, 2025, I move that the commission grant their request. So moved.
As to the motion that's been heard, is there any further discussion? Hearing none, all those in favor signify by saying aye. Those opposed by no, the ayes have it. The motion carries.
Item number 11 is in docket number 2025-3E. This is a petition from the South Carolina Energy Users Committee to intervene out of time.
As to item number 11, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. On August 8th, 2025, at 10:54 a.m., the South Carolina Energy Users Committee filed a petition to intervene out of time pursuant to Regulation 103-825. The published date for the intervention due date was until August the 6th, 2025. The South Carolina Energy Users Committee missed the intervention date by less than 2 days or approximately 35 hours. The Energy Users Committee and its members, primarily industrial companies, consume and purchase substantial amounts of electricity from Duke Energy Carolinas. The subject matter to be addressed and resolved by the Commission in this docket. They have a real material and substantial interest in this docket. In fact, I would note that the South Carolina Energy Users Commission has intervened and participated in the annual review of Duke Energy Carolinas fuel costs for more than the past 10 years. The date for intervening parties to file direct testimony and exhibits is August 26, 2025, and the South Carolina Energy Users Committee states that it is prepared to comply with the current procedural schedule. I move that the Commission find and conclude that the South Carolina Energy Users Committee members will be impacted by increased electric rates, charges, and tariffs as proposed by Duke Energy Carolinas. The participation by South Carolina Energy Users Committee will aid in providing a full and complete record for the Commission to consider in making its decision. I further move that the Commission find and conclude that granting the petition to intervene of the South Carolina Energy Users Committee will not affect or delay the proceeding in this docket, and that granting this petition to intervene is in the public interest. In fact, granting the petition to intervene is consistent with policies of the Commission and in encouraging maximum public participation in issues before it so that a full and complete record addressing the views and concerns can be developed. For these reasons, I move that the Commission accept and grant the petition to intervene out of time filed by the South Carolina Energy Users Committee, and that the South Carolina Energy Users Committee shall be made a party of record in the docket.
Thank you, Commissioner Williams. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
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 Those opposed by no, the ayes have it. The motion carries.
Mr. Chairman, that completes the utilities agenda before the Commission. Moving on to the motor carrier agenda. In Part A, there are 7 applications for new Class C and Class E certificates that the Commission can address together. Item A1 is in docket number 2025-222T, which is the application of Premier Journey Transportation, LLC, for a Class C non-emergency certificate. Item A2 appears in docket number 2025-223T. This is the application of Fusion Trucking, LLC, doing business as Fusion Transportation, for a Class C non-emergency certificate. Item A3 is in docket number 2025-225T, which is the application of J&E Services and Solutions, LLC, for a Class E household goods certificate. Item A4 is in docket number 2025-227T, which is the application of Charter Transportation Services, LLC, for a Class C non-emergency certificate. Item A5 is in docket number 2025-228T. This is the application of JBG Transports, LLC, for a Class C non-emergency certificate. Item A6 is in docket number 2025-229T, which is the application of Treasured Hearts Transportation Services, LLC, for a Class C non-emergency certificate. And item A7 appears in docket number 2025-231T, which is the application of Arms of an Angel, LLC, for a Class C non-emergency certificate.
As to items A1 through A7 as presented by Mr. Scarborough, is there a motion?
Chair Powers,
Commissioner Caston.
I move that the Commission approve the applications for Class C and Class E certificates and agenda item numbers A1 through A7 as identified by Mr. Scarborough. A directive order will be issued in each respective docket granting the motor carrier application. So moved.
Thank you. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion's carried.
In Part B of the transportation agenda, there are 2 requests for extensions of time. Item B1 is in docket number 2025-132T. This is a request from Foots Transportation, LLC, for a 3-month extension of time to comply with Commission rules and regulations.
As to item B1, is there a motion?
Chair Powers?
Commissioner Williams.
Thank you. I move the Commission grant the request of Foots Transportation, LLC, for a 3-month extension of time until November 14th, 2025, to comply with Commission rules and regulations by completing the certification process. Pursuant to paragraph 5 of Exhibit A to Order Number 2025-273, granting authority to provide motor carrier services, which was issued on May 8th, 2025. The certification process requirements are that the applicant must file with the Office of Regulatory Staff proof of appropriate insurance and also tender payment of license fees, as well as provide such other information required by law to the Office of Regulatory Staff. So moved.
Thank you, Commissioner Williams. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item B2 appears in docket number 2025-139T. This is a request from Charleston Care Rides LLC for a 12-month extension of time to comply with commission rules and regulations.
As to item number B2, is there a motion?
Mr. Chair,
Vice Chair Williams.
Mr. Chair, fellow commissioners, I move that the commission grant Charleston Care Rides LLC an extension of time until May 16th, 2026 to complete the certification process by complying with commission rules and regulations. Pursuant to paragraph 5 of Exhibit A to order number 2025-291A, granting the authority to provide motor carrier services, which was issued on May 16, 2025. The certification process requirements are that the applicant must file with the Office of Regulatory Staff proof of appropriate insurance and also tender payment of license fees, as well as provide such other information required by law to the Office of Regulatory Staff. If Charleston Care Rides LLC needs additional time beyond May 16, 2026 to comply with commission rules and regulations, Charleston Care Rides LLC must file a new application. So moved.
Thank you, Vice Chair. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part C of the Transportation Agenda, there are two requests to suspend certificates, which the Commission can address together. Item C1 is in docket number 2023-308T. This is a request from Luxury Limousines Incorporated to suspend Class C Charter Certificate number 9884 for 6 months. And item C2 is in docket number 2022-213T. This is a request from ADF Transportation, doing business as Sea Island Transportation LLC, to suspend Class C Charter Certificate number 9700 for 12 months.
As to items C1 and C2, is there a motion?
Chair Powers,
Commissioner Thomas.
I move that the commission grant the requests for suspension from the motor carriers and agenda items numbers C1 and C2 as identified by Mr. Scarborough. A directive order will be issued for each respective docket granting the request for suspension.
Thank you, Commissioner Thomas. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Mr. Chairman and Commissioners, this concludes all business notice before the Commission today.
Thank you, Mr. Scarborough, and thank all who have joined us. Our next meeting, as stated, will be July 24th at 1 o'clock, August 24th at 1 o'clock. Thank you very much. We are adjourned.